Hi everyone, I am Dr. Alice Taylor and I am a part-time commissioner at the Queensland Law Reform Commission. Thank you for being here for what will be hopefully a very engaging session exploring the different ways to gather, use and give evidence in law reform. And I think some of the themes that should emerge in our conversation really fit with what has already been discussed in terms of thinking about the benefits of institutional law reform. So as we've heard since the very beginning, law reform was designed to go beyond purely doctrinal research. As Justice Kirby highlighted yesterday, the purpose of the ALRC was to serve the people. And as we heard yesterday as well, one must carefully listen to those who have been impacted by the law, particularly where they do not speak in legal terms. But there remains a question as to how one effectively listens to the people. So traditionally, as we know, law reform primarily uses legal doctrinal research supplemented by consultation and stakeholder feedback. That stakeholder feedback has expanded to include the lived experience of people impacted by the law, but it frequently also includes key organisations and individuals in the legal community, including law societies, law schools and judges. Feedback was usually obtained by face-to-face consultations and written submissions in response to consultation documents prepared by the law reform body. As we heard yesterday, this thorough approach to consultation is a unique advantage of institutional law reform. However, law reform bodies are increasingly expanding their approach to law reform methodology to increase the breadth and diversity of individuals consulted during law reform review and to enhance the research rigour by using qualitative and quantitative research tools from the social sciences. However, there may remain challenges and tensions in adopting a broader approach to gathering evidence in law reform. This methodological expansion raises fundamental questions about the role and legitimacy of law reform bodies that requires careful examination. A critical tension emerges when quantitative research reveals community attitudes that conflict with established legal principles and professional consensus within the legal community. The challenge becomes more complex considering how law reform bodies can be responsive to community feedback, guided by expert knowledge, and seek to balance both through transparent deliberative processes. Resource constraints present another significant challenge, as social science methodologies require specialised expertise, extended timeframes, and funding. Is this resourcing best achieved through developing internal capacity or partnering with external organisations and academic institutions? The integration of diverse methodologies raises questions about analytical rigour. How can law reform bodies ensure that qualitative insights from community consultations are weighed appropriately against quantitative survey data as well as traditional legal analysis? Finally, what frameworks can law reform bodies establish to ensure that these expanded approaches will actually improve law reform outcomes? So the panel will examine the utility of different approaches and explore the ways in which law reform bodies can and do utilise different approaches to evidence gathering. So on the panel, we have Matt Corrigan, who is the Executive Director of the Secretariat Support Branch within the Department of Justice and Attorney Generals, which manages the Secretariat to the Queensland Law Reform Commission, the Queensland Censorate Sentencing Advisory Council, and the Public Trustee Advisory Monitoring Board. Before joining the department, Matt was General Counsel and Senior Executive Leader at the Australian Law Reform Commission from 2016 to 2023. In that role, he led 9 law reform inquiries on diverse topics such as financial services legislation, civil procedure, corporate criminal responsibility, family law and elder abuse. Prior to joining the ALRC, Matt had a diverse legal career and worked in Bangladesh, Myanmar and South Sudan. Matt holds an LLM with merit from the ANU and a Bachelor of Arts Honours and a Bachelor of Laws Honours from Melbourne University. Then we have Jacinth Pathmanathan, who is a principal legal officer for the ALRC's review of surrogacy law and previously worked on the ALRC's justice responses to sexual violence inquiry. Before joining the ALRC, she was a project lead on several inquiries and projects at the Victorian Law Reform Commission and RMIT Centre for Innovative Justice. She has worked in federal and state roles, including at the Department of Prime Minister and Cabinet and the Victorian Royal Commission into Family Violence. She began her career as a research associate at the Supreme Court of Victoria. She holds a Bachelor of Laws and Bachelor of Commerce from the University of Melbourne and a Master of Laws from Columbia University in New York. Through her work, she has designed and implemented new ways to improve the legal system that are grounded in current research and strong stakeholder and community engagement. And finally, we have Liam Elphick, who's a lecturer at Monash University Faculty of Law and an LGBTIQ+ community leader and advocate. He was previously the co-convener of the Victorian Pride Lobby and advised the Victorian Government through its LGBTIQ+ Task Force Justice Working Group. His expertise is in law reform and LGBTIQ+ discrimination law, particularly as it intersects with religious freedom. Liam is a member of the Australian Discrimination Law Expert Group and has contributed to over 40 law reform submissions in discrimination law in the last 7 years. Okay, so to open up our questions to Matt, what do we mean by new or modern approaches to law reform? What do we mean by evidence when we're thinking about law reform?
I thought what I might do to start this discussion is to bring it down to quite a concrete and specific example of what we mean. We did ask if it was on, but no. Okay, starting again. I thought to try and contextualise this in a concrete way, we might start with an example about data. So I was really privileged to work at the ALRC with Ros and Matt Myers on the over-incarcerations of Aboriginal and Torres Strait Islander people's inquiry. And in addition to an important year-long consultation process where we went out on country and we spoke to people, we also wanted to really understand the data. And by data, I mean, the criminological data. And as a piece of data, what was really interesting to us was that all of the Commonwealth's policy frameworks around criminal justice, around the over-incarceration, was based on ABS data. And ABS data relied on stock figures, and I'm going to borrow some language from Don Weatherburn to explain that. When we look at prison populations, there are two statistics. There's flow and there's stock. Flow talks about the population going into prison, and stock is an annual stock take of who's in prison. By relying on stock, what Don Weatherburn says is you're really underestimating the proportion of people who are serving very low or short sentences. So what the Commonwealth saw through the stock figures was that when it came to Aboriginal and Torres Strait Islander offenders, 10% were receiving a sentence of less than 6 months. So the whole policy framework was around prisoners who are serving long sentences and often for very violent crime. Through the research that we were able to do with Curtin University, we were able to get flow statistics. And what that showed was that actually 45% of Aboriginal and Torres Strait Islander people in prison were in prison for less than 6 months. Not 10%, but 45%. So the demographics of that population, the offending type, were fundamentally different when you looked at that one different statistic. And having that statistic really enabled us to explain the reform agenda and to frame the reforms around a much more nuanced and thorough understanding of what was happening on the ground. And it was startling in one way that one statistic can make all the difference in a policy debate. And I think it's the ability of law reform commissions to engage with it in quantitative and qualitative research, in addition to that doctrinal research, in addition to that consultation, that really gives you the evidence base for reform.
Anything to add to think about what we mean by evidence in law reform? To Matt's really excellent example of quantitative data.
Yes, that was very helpful, Matt. I don't really have a whole lot to add aside, I guess, when it comes to trying to identify what the evidence base is. It is really going to the quantitative data. It's about exploring qualitative methods such as focus groups, surveys. We've talked over the last day about things like impact assessments, demand modeling. I think it's really sort of, fanning out from the typical, doctrinal analysis, submissions and consultations, and really widening it that way. And that was a really good illustration of how that would work.
Yeah, I think what I'd add as well is the qualitative storytelling that matches the quantitative data as well. And I suppose in my space, particularly in LGBTIQ plus discrimination law and religious freedom and how that intersects, In the law reform inquiries I've been involved in, the storytelling and the hypotheticals, as well as the real world examples, have made a huge difference and really break through. And I would treat that as evidence, I think, because you're really sort of putting meat on the bone to the data that you get from those sort of surveys and those sort of sources that Matt talked about. So I think, it sometimes isn't overly impactful to go out and talk to people and say, oh, section 38(2) of the Sex Discrimination Act says that if you act in good faith and conduct blah, 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 blah. If instead you say the current law allows religious schools to refuse to hire gay teachers, and then you provide an example where that's actually happened, I think that's a lot more powerful and resonates with people, particularly in the public, particularly through the media. And you need that doctrinal evidence base underneath it. You need the section numbers and the unpacking of that as well. But I suppose it goes to the point that the previous panel talked about. It's having both the detail underneath it and the summary and the easy to understand, digestible example of what that evidence means on the ground to sort of really fill in the picture as well.
So I'll give this first question to Jacinth, which asks, based on your range of experiences with different law reform bodies, how have different bodies that you've worked in maintained core legitimacy and balance of focus and adherence to doctrinal research and thorough stakeholder consultation, as well as new methods of research?
Thanks, Alice. I think it is interesting how this topic is framed, because often I think it's framed as a trade-off between what doctrinal research gives you versus what qualitative or social science research gives you. And I really do think that they are complementary and reinforcing, and qualitative methods really do, and quantitative reinforces the legitimacy of the process. As Matt says, it completes the picture. It helps you avoid groupthink or in echo chamber. It gives you a more representative sense of the problem and what the solutions might be. So I can only really see, I see benefits in using them in parallel, but probably a key point is to ensure that you're using them properly. And it sounds like, Matt, in the example you gave, that there was a lot of thought given to how you use the quantitative data and what that meant. And at least at the ALRC and even at the VLRC, which is where I worked previously, we were very careful at the start of the inquiry to think about the sorts of evidence we need. So doctrinal research might serve a particular purpose. It will help you identify the legal problem, to understand how that problem has manifested, but it doesn't really give you a sense of how common it is or how it affects people on the ground. And the impact it has perhaps on behavior change. So you need to decide at that very, very early point, what are the sorts of evidence you need, and then what is the best way of acquiring that evidence, whether that's by getting things from off the shelf or commissioning some research or partnering with people in the community. And I think another thing that has been at the forefront of the research process at these commissions has really been being careful about how you triangulate the various sources of evidence and how you assess quality. So you might use doctrinal research for a particular purpose, but the quantitative data serves another purpose. With any of it, you do need to think about how the evidence was gathered, whether the methodology was sound, what the limitations were. So I think working through those steps carefully, triangulating the evidence carefully, assessing it carefully, all enhances legitimacy rather than detracts from it.
Yeah, I might just add by saying I think it's really helpful to clarify what the problem is that you're trying to solve in law reform, and maybe distinguishing between what problems are more legal, doctrinal problems and what problems are more social, on the ground problems. You could have the best law in the world doctrinally that looks like it should work in every possible way, but you have claimants or people in the community who have no idea how to use that law, or you have enforcement mechanisms that don't work for those people. And I think the examples given in the previous panel around our Indigenous population is probably the best example or worst example of that. So identifying where a problem is, for instance, more social and doesn't require necessarily technical changes to the law, but instead changes around how we communicate about the law and how we educate about the law, and the systems of law that work around that is really important, because I think that's how the evidence base feeds in. Almost any law reform is going to require doctrinal evidence and empirical evidence, like qualitative and quantitative evidence, but the balance between the two can be quite different. And I think, even the example that some in the room will be aware of the Burns and Corbett case and Chapter 3 courts, I'm not going to bore you all with it, but, these sort of enforcement mechanisms that can be really challenging that no one in the community is really going to have any understanding of. That's a deeply technical problem that requires a deeply technical response, and it has been given a legal response in most jurisdictions in Australia now. Whereas in my area of discrimination law, often the problem is people just not knowing how to access that law and what to do when they want to make a complaint. And a lot of that is not so much grounded in the law, but grounded in the sort of systems around the law and how we bring people and bring the community along with the law. And so that might not require a legislative change, but a much more sort of soft power or soft law kind of change.
Do you have anything to add?
I think my brilliant co-panelists have answered that one.
Amazing, because I am now going to go back to you. Now, originally, I was going to ask Kate, who unfortunately can't be here, to discuss her experience doing focus group research for the Queensland Law Reform's inquiry into criminal defences, because Kate, as well as some researchers from the ANU, did some really amazing focus group research on community attitudes to criminal defences in Queensland. And because Kate isn't here, instead, I will switch to Matt to discuss his side of the process, and in particular the decision to engage independent experts to undertake this particular form of research, rather than just doing quite an expansive consultation, which was also done as part of this review as well.
Well, I'm certainly not Kate.
Yeah.
So we at the Queensland Law Reform Commission, and we're nearly finished now, but we've got what I think is a really exciting review, and it's a review into criminal defences in the criminal code. So looking at things like self-defence. In Queensland, we still have provocation, and some newer defences that we've tried in Queensland in order to respond to the scourge of domestic and family violence. The terms of reference explicitly asked us to consider what reforms, if any, are needed to those defences, having regard to contemporary attitudes. So we've been explicitly asked to examine what the community thinks about those defences. Now, there's obviously different ways we could go about doing that, but we thought it was really important to, in a systematic and rigorous way, really try and answer that question as to what the community thinks. Now, the value that Caden had and the team at ANU brought was that they were really able to design both a community attitude survey and some focus group research that was very rigorous and would withstand academic scrutiny. And so what we did was, because these defences are quite complex, the survey and the focus groups were based around vignettes. So we were looking at different scenarios, a little bit like exam problems in some ways, and we would change different variables in those stories. So in one case, there was a fight at a football field. In another, the difference was that someone had insulted his girlfriend and then he punched the guy. So we changed different variables, and we're then looking to the way in which people responded differentially to those scenarios to really ascertain what the community attitudes were. And this was a really powerful for us augmentation of the traditional consultation process, because it enabled us. We had 2,500 participants in the community attitude survey. We then conducted the focus groups really to sort of tease out in a more qualitative way what were some of the reasons for the rankings that people gave in the survey, what was their thinking about certain scenarios, and it really gave us a rich understanding of what community thought. And I'd be interested, Alice, as a commissioner, what you thought about that process.
I also, seeing and hearing this research once it was done, found it incredibly compelling in terms of thinking about how to construct and defend particular positions that the Commission might take, because it may sound to a government not particularly politically palatable, but you could point to really rigorous research, which wasn't just focused on consultations, but had this social science rigor behind it to say what the community actually thought, and provide some of those examples, which meant that you could say, well, in these sorts of situations, this is what the community actually thinks. And so I found that really useful to reflect on where the Commission should go in particular directions on the recommendations made. And it provided a really compelling, useful basis to refer back to when thinking about recommendations, and to say, well, is this consistent with community standards? Well, I can go back to that research and say, well, yes, it is consistent with community expectations because I have research to support that and back it up. And it complemented the consultations done. So the consultations maybe didn't always agree with the focus group research, but you could see how they could fit together and create a really strong narrative around any recommendations the Commission made, particularly around potential changes, which I think the government may or may not find controversial in some respects, but it allowed for that evidence base to be given. I think I would also be interested with Matt to talk about, I know that from my experience with the Queensland Commission, how much upskilling has been done in terms of methodology internally as well. So both the engagement of independent experts in the social science, but I also know that internally there's been a lot of work done in upskilling the Commission in those skills. So I'm interested to hear more about the thinking behind that balance.
It is, I mean, one of the challenges for us is always resources, and I think that's been a common refrain of law reform commissions. So it is a delicate balance. What we did in this case is we had resources for this review to engage one criminologist, which really helped us to design the survey and to actually effectively draft the terms of reference for these external experts to do that work. And without that, I think it would have been really difficult, because it's kind of, how do you ask the question if you don't know what the question to ask is? And certainly, so for us, it was that mixture of, we knew that we had the only way to do a proper, rigorous community attitude survey and focus group was to do that externally, but we did need the internal resources to really help us design that. And then the real value of that internal perspective, and I'll give a shout out because I know that the team back in Queensland is watching, to Helen Punter, who's our principal research analyst. Really, her role was not just to lead that criminological research, but to really help build the team's capacity for that research. So to really understand the different methodologies, to understand what things mean. We often talk about things in a very, we talk about doctrinal research or qualitative research in a very vague way, whereas Helen will always talk about, well, is that difference statistically significant or not? And if it's not statistically significant, then we're not talking about it. And so I think having that rigour and having that conversation internally has been really valuable as well.
Do either of our other panellists have anything to add in terms of the qualitative research and the upskilling internally or externally, or partnering with external organisations or experts?
Well, hopefully this is still on. Yeah, I agree that I think that there are probably two sides to it. One is the internal upskilling, whether you're doing it yourself or just needing to understand how to use the evidence, how to ask the questions, how to analyze it. I think there is that piece where, often in law school, which is where most people who work at law reform commissions come from, we would have very little to do with qualitative research and being able to grapple with that research in a meaningful way. So, yeah, I think there is a piece around being able to work with that evidence effectively, but also just acknowledging the resourcing point that these inquiries are very diverse. You might, for example, need a data scientist or survey methodologist for one inquiry, but you might need community engagement specialist or an evaluation expert for another inquiry, and it's not really realistic to have everyone on staff all the time. And that's where I think partnering is really good in the sense that it's resource effective, but also quite flexible, and you can adapt based on the inquiry.
I think I'll just add that, like, from my perspective, working at a law school, we are not good at teaching or embedding skills around empirical research. I just think that's the reality right now. We're getting better at it, and there are some fantastic people doing empirical research. Dominic Allen is one who's in the room, and Alicia Blackham at Melbourne, and some other fantastic people who are starting to embed this work more so in law schools. But, you know, we're not really training our students to do empirical research in the way that I think we could or should be doing. And even sort of transitioning through into academia, I feel like this is not a major part of how we upskill either. I was really lucky. My first job was at the University of Western Australia, and I had some fantastic colleagues who I worked with on a study of student attendance in law schools. It's low in classes, and I was very lucky to be part of that process. And, you know, we surveyed, I think, 1,000 students and 45 staff. And so I felt really grateful to be part of that. But the reality is most academics are also not involved in that most of the time. And so I think we have to recognise our limitations when we come to law reform in terms of that base, that we need to both partner with other organisations who can do that work and start embedding those skills more in the undergraduate level and in academia so that it feeds into our research more clearly. My view is doctrinal research really matters. Like, it's fundamental. It's mostly what I do. But the more we can get involved in and support that empirical research as legal researchers and lawyers, I think the more that will feed into that work with partners when it comes to the pointy end of law reform.
I will say, particularly in terms of the QLRC experience, it has been really amazing to see the upskilling of staff internally and the kinds of analysis that the Commission is now able to do, which really, like, you know, creates such a fundamental and strong basis for recommendations that are made. And so it's been, like, just amazing to watch this kind of analysis emerge and have everyone be able to kind of speak the language of qualitative and quantitative data in the way that, as Liam is saying, we may not have learned at law school, but it is something that is a real valuable skill, I think, in law reform. My next question does look, and I completely accept Jacinth's points of are these actually in tension, but my next question does somewhat go to the tension, which is to say we have all this now fantastic qualitative and quantitative research, but we can also find that it conflicts with some of our traditional stakeholder consensus on matters. So what our stakeholders in the legal profession may claim is the appropriate position may conflict with some of this other analysis that we're doing around community viewpoints, or in terms of the quantitative data that is coming back. How do we deal with those tensions when they resolve between particular stakeholder positions that are presented in consultation and often presented as fact and true versus what may be coming out in the data, and reflect both of those positions? So Matt, do you have an opinion?
Yeah, I mean, I think that's a really interesting one. And again, Alice, I might take the abstract and bring it down to the practical, and maybe to actually what we've been grappling with at the QLRC. So, as I said, we're looking at criminal defences, and one of those is in Queensland. We're one of the last states to have a defence of provocation, which really is seen to privilege male violence and responding out of anger and jealousy. Our community attitude survey was overwhelming that the community doesn't accept that people should receive a lesser sentence, a lesser criminal punishment in those circumstances that we expect in 2025 for people to control their emotions. We have then the profession saying, well, provocation, particularly in relation to murder, is a really important defence because in Queensland we have mandatory sentencing, and if we have mandatory sentencing, there's no way to reflect any differential responsibility. So there's a real tension there, I think, between what our community attitudes survey is telling us and then what the profession is saying, having regard to not just the defence but that contextual reality of the mandatory sentence. To answer the question, I think this goes back to what Ros was saying in the last session, and I think for all of our reviews, we really set out a framework that sets out our values and our principles. And it's really important then to explain in the report, when we're making those decisions, how the principles and values have informed the decisions we've made. One of the great things about, I think, law reform reports is that it's an opportunity to explain your reasoning. It's an opportunity to say clearly and transparently, we were faced with this choice, this was the decision we made, and these were the reasons behind that. These are the values and the principles that have informed the conduct of this review and the decisions we've made. And I think that transparency is, really best practice. And I think that's how we do it. I don't think there's any easy answer there, as you would know in the room. They're really hard things for the Commission to decide on. But I think being clear about your values, your principles, and being transparent about it.
Yeah, I agree. I echo what Ros said about the reform principles, and just knowing what your reform aims are can help resolve these tensions that do arise. And I think trying to bring it down to the practical as well. I was just reflecting on an experience I had at the VLRC where I was working on the sexual offences inquiry there, and we ultimately made a recommendation for the government to introduce amendments to introduce affirmative consent in the criminal law. At that point, I would say the profession was quite against it, and possibly still is. But there was quite a lot of advocacy, particularly from the sexual assault sector and from people with lived experience, really, advocating for this change to be made. While at the same time, I think big chunks of the community probably didn't even know what it was, and were not aware of the debate. So I think based on our reform principles, based on our reform objectives, the Commission did decide to go ahead and make the recommendation, but we thought very carefully about what sort of buy-in we would get, and also what sort of opposition we would get from the community. And the way I think we reflected that in the recommendation was to think very carefully about the exceptions that were made in the law, so that people wouldn't inadvertently not comply with it because they weren't aware of it or didn't buy into it. So really trying to think about those exceptions, and that I think also helps appease people, for example, like the criminal bar. In those situations, thinking very quite a lot about public education to accompany the recommendation, because there was clearly a piece that people who weren't aware of the law could very easily breach it. And also thinking about enforcement as well, and to what extent do you enforce, and how you go about that.
Yeah, I totally agree with all that. And I suppose to go back to your question, Alice, I'll give the answer that my students always hate when I give it, which is it depends. And I think it's very loyally. And it depends on a couple of things. I think it depends on what we mean by community views or sort of the data that we're receiving. I think we're living in an age where data is so simplified now and reduced to such a level, and sort of questions that are asked are reduced to such a level, particularly in the media, that we can mistake those attitudes and views for broader attitudes and views. And I can think of two examples that are opposite examples on this to shed light on that. The first is the religious discrimination bill, which many in the room would remember sort of took place between 2019 and 2022. Now, at its core, the idea behind that bill is that we protect people of faith and not of faith from discrimination. So we make it unlawful to discriminate against someone because of their religion or lack of religion. On that point, on that proposition, there is widespread support, as there should be, on that fundamental point that we don't discriminate against people on the basis of their religion. But because of how that bill was crafted and how that debate played out, and some problems with that bill that were fundamental to it, when polling was done around a year after that bill had been released on support in the community for the idea of a religious discrimination bill, there was very little support for that bill. Like overwhelming majorities in almost all sectors opposed the idea of the bill. But that's not the same as opposing the actual fundamental idea underneath it, which I just talked about then, which is that we oppose, discriminating against people on the basis of religion. So if you just took that headline data, that would suggest, we shouldn't have this bill. So I think digging underneath that to understand what those community expectations are and what that awareness is really important, because the opposition to that bill had very little to do with that fundamental premise and had a lot to do with how the government at the time used it in a way to be weaponized against other groups. So that was, an entirely fair response to those issues, but had nothing to do with that fundamental premise. And so as we sit here today, we still don't have that federal protection because of how that debate played out. So that would have been a situation where, from my perspective, and this is certainly what I submitted at the time, we need this bill, but not in this way. And unfortunately, because of how expectations took over around that bill and how I suppose that's fed into broader social discourse on religious freedom and religious discrimination, that never saw the light of day after that and probably won't for a long time to come in terms of any form for that bill. On the flip side, I can think of another example where I think it would have helped a lot more to listen to community expectations, and that's around the recent Victorian hate speech or anti-vilification reforms. And so that's a process that also took about 6 years from start to finish. And part of those reforms were expanding our hate speech laws to protect women, LGBTIQ people, and people with disabilities. One of the groups that was going to be included in the original reforms was people living with HIV. And so there would be a label, like an attribute in the law saying, it's unlawful to vilify people on the basis of their HIV or AIDS status. And in the last stage of those reforms, the government took out that wording from the reforms on the basis, rightly, that people living with HIV are protected by the disability protections. So substantively, people living with HIV are protected. But what we were talking to LGBTIQ advocates about and people living with HIV and their advocates about was that it's really important to see yourself in the law, not just to be substantively protected. And so the more and more that I talk to people living with HIV, the more important it became and clear it became to me that having that label in the law matters substantively, because these are people who may not otherwise think they're protected in the law, or they might not want to self-identify as having a disability. They may not see themselves in that way, and they therefore may not use the law. And so that's an area in which I think it would have been really important and helpful if we had listened and if the government had listened more to those advocates and to understand those perspectives. So I just think those are two examples and different examples. One in which maybe, we listen too much to those overriding views because they are simplified and distilled by the media to be yes or no, black and white. And another example in which it clearly affects a particular community and we should listen to that community in terms of what they need, even if substantively in the law it maybe doesn't change anything, it matters to them in terms of how we understand those community expectations.
Okay. My final question for the panel is to think back to consultation, which, as we've said, is one of the fundamental parts of law reform, and it is one of the true benefits of institutional law reform in particular, that it does thorough, focused and genuine consultations with people. But I think one of the things that I know the QLRC still grapples with is how do you ensure that that consultation is truly inclusive, that you are reaching a wide range of opinions. So, Matt, what has the QLRC been doing in recent years to ensure that consultations are going beyond the usual stakeholders, but reaches a really diverse range of voices who may not be in the focus groups and may not be generally community standards, but instead really deserve to have their voices heard in this process?
I think it's consultation really is the heart of what we do. Listening is at the heart of what we do. And I think in a society that's filled with a lot of noise, listening is really, really powerful and so important. And it's through listening that we enhance our understanding. So I think it has to be at the core of what we do. I think what we've been doing, what we certainly did at my time at the ALRC and now at the QLRC is really, and Ros, I think in the last session really touched on that, and that is looking at the way in which we build relationships with the community. It can't be this transactional dynamic that we've got a terms of reference, we consult you, and then we move on to the next thing. It's about building relationships. So we've spent a lot of time over the last 2 years travelling around Queensland, going to particularly Aboriginal and Torres Strait Islander communities and having discussions with them about law reform, who we are, what we're doing, what their interests are. So going beyond just the immediate terms of reference and building a relationship and making people hopefully feel comfortable to come and talk to us, share their ideas and share their stories. That takes a lot of time and commitment. And but I think it's certainly from our side one that is very genuine. I know when we recently went up to the Torres Strait as part of our 2 criminal defences reviews, one of the nicest things was the day after we were celebrities because we were on all of the local Facebook groups. Oh, we met with these people from the QLRC and we had this great chat, and you're like, well, that's a measure of the fact this was a genuine conversation. This was something of value to them. It wasn't just us coming for a chat, taking what we wanted and leaving. And if you do get the opportunity to go to the Torres Strait, I highly recommend it. It's one of the most beautiful parts of the world. So.
And I think we both didn't just do in-person consultation, which was so valuable, but there was a lot of thinking around how information was presented and relayed to people so that they knew about the QLRC. So thinking about the language that was used in documents and ensuring that it was fit for purpose. There was a lot of work put into that to ensure that it could engage with communities in an effective way. So I think it built over time to create a situation where relationships could really be formed.
Yeah, so at the QLRC, we have an Aboriginal and Torres Strait Islander expert panel that's chaired by Evelyn Tarago, who's the First Nations woman and a commissioner. And that's a really important for us to have at that leadership level, that guidance from Aboriginal and Torres Strait Islander people in about the way we go about consultation, the way we present materials. And it's a really important signifier that we are not consulting to people, that we do want this partnership and we want people at that leadership level to guide us. And I think that's been really invaluable.
Yeah, completely agree with what Matt said. I think at the commissions I've worked at, we think carefully about the composition of the team, who the commissioner is, who the assistant commissioner is, and on some level, I think that can help build trust and facilitate better consultation. We try to make our products as accessible as possible, so thinking about things like easy English papers, providing different ways of making a submission, being very flexible about consultations. That said, I completely agree with the previous panelists and Matt that I think that only really takes you so far. And really, I think you do have to go out and be with the community. Sometimes I think also it's about having the humility to realize that maybe we're not the best people to be consulting with this community. Is there another way of reaching them, for example, through a trusted service provider, through a trusted community organization, or perhaps through more of a research process like focus groups where people feel like they can speak freely. But yeah, that's all I'll add.
And I'll just make a quick point because I know better than to get in the way of everyone and morning tea. I just thought I'd add, even the most doctrinal process or law reform submission should be grounded in consultation. So I'm a member of the Australian Discrimination Law Experts Group, which is a group of legal academics who have expertise in discrimination law around Australia, and we make group submissions. And even with our incredibly doctrinal, dense, sort of technical submissions, throughout that process, we're involved in consulting with the communities that are affected by it. I think back to the Respect at Work reforms around sexual harassment. I don't think it's possible for us to understand what the law on sexual harassment should be without talking to and listening to victim survivors. Like, I don't know how you can actually understand what the law needs to be and how to fix problems in the law and how to implement the reforms from Respect at Work without listening to those people. And we were part of this broader coalition called Power to Prevent, whereby we did engage with those groups and listen to them. So I think it's important for everyone involved in the process, not just the commissioners, not just the people going and doing research, survey consultations, to do it informally, substantively throughout, to really understand and listen to the people who are affected by these laws.
Thank you so much. And it is 11 o'clock, so we are perfectly on time. So can we please thank our amazing panellists for their insight.